The courtroom was full and they were all looking at her like she had walked into the wrong building. Maybe she had. That was what the man at the security desk had implied when she came through the doors that morning. Not with his words. Exactly. But with the way his eyes moved from her face to her file folder and back again, as if he was waiting for her to realize her mistake and leave on her own. She didn't leave. She signed in, clipped her visitor badge to her jacket lapel, and took the elevator to the 4th floor. And when she sat down in the back row of courtroom 4B, nobody said anything to her face. They just talked around her like she was a piece of furniture that had been delivered to the wrong address. Her name was Lena Okafor Briggs, 29 years old. She had grown up in Cleveland in a 2-bedroom apartment where the heat went out every February, and her mother kept a list of Bible verses taped to the inside of the cabinet door above the sink. Not because she was especially religious, but because, she said, some days a person needs a sentence that was put together better than they could manage on their own. Lena had her mother's handwriting. She had her mother's habit of going quiet when she was the most upset. She did not. The partners at Calhoun, Draper and Fitch, had made clear in a number of professionally worded ways over the past 14 months, belong in their firm. She had been hired as a junior associate out of Howard Law 2 years ago. She had graduated 4th in her class. She had a memory for precedent that her contracts professor, a retired federal judge named Whitmore, had called. In a moment he probably didn't remember, and she certainly did. Almost unnerving. Almost. She had been assigned to the Alcott case on a Tuesday in March, which meant someone had made an error. Because the Alcott case was not the kind of case they gave to junior associates who graduated from Howard and grew up in Cleveland. The Alcott case was the kind of case that appeared on the firm's website under the heading Landmark Litigation. It was 11 years old. It had survived 3 appeals, 2 changes of lead counsel, and a circuit court ruling that the senior partners referred to, in hushed voices in the conference room, as the problem. The problem was this. Meredith Alcott, age 71, had been the primary cardholder on a joint account with her late husband for 38 years. When her husband died, the bank had transferred the account entirely into a trust controlled by her adult son, on the basis of a document that Meredith claimed she had never signed. The bank said she had. They had her signature. Or something that looked like her signature. The forgery, if it was a forgery, had survived a first-round document analysis and a deposition that lasted 4 days. And the previous lead attorney, a man named Callum, who had left the firm under circumstances nobody discussed out loud, had spent 3 years building a case around financial coercion before losing on procedural grounds. The case was by the consensus of every senior attorney at Calhoun. Draper and Fitch, unwinnable. Senior partner Raymond Draper had said so out loud at a firm meeting in January. He had used those exact words. This case is unwinnable. He had said it the way people say things they want to be repeated, slowly, with a pause before and after like a man setting down something heavy. The other partners had nodded. The associate attorneys had looked at their notepads. Nobody pushed back, because Draper had been practicing law for 41 years and had won cases in 9 federal circuits and once. This was the detail that got repeated at firm dinners like a piece of scripture. Once had cross-examined a sitting senator and made him cry. Lena had not been at the January meeting. She had been in the basement of the county courthouse, pulling archived documents on a slip-and-fall case that she had not been named on and would never be credited for. She found out about it the way she found out about most things. By accident, from a filing she wasn't supposed to see left on the printer by a paralegal named Cheryl, who was always in a hurry and never sorted her output tray. The document was a draft motion to dismiss, filed on behalf of the firm, against their own client. Calhoun, Draper and Fitch, was preparing to drop Meredith Alcott. She read the document 3 times in the copy room, with the door closed. Then she went back to her desk, opened the Alcott file on her computer. She was listed as a document reviewer, which meant she had access but no standing. And she started reading from the beginning. She read for 11 days. She read at her desk during lunch. She read at home on her kitchen table, with her dinner getting cold next to her laptop. She read the deposition transcripts and the forensic accountant's report, and the original account documents and the 38 years of joint statements that had been subpoenaed and filed, and largely ignored by everyone who'd worked the case before her. On the 12th day, she found it. It was not dramatic. It was not a smoking gun hidden in a file marked "Do Not Open." It was a date. Specifically, the date on the trust transfer document, the one bearing Meredith Alcott's supposed signature, was a Tuesday in October, 11 years ago. A Tuesday. And in Meredith Alcott's bank records, subpoenaed but never fully analyzed, there was a wire transfer made from a branch location in Phoenix, Arizona, on that same Tuesday. A wire transfer that Meredith had made in person. The branch manager had initialed the transaction log. Meredith Alcott could not have been in two places at once. She could not have signed a document in a bank office in Columbus, Ohio, and simultaneously wired money at a branch counter in Phoenix. One of those things happened. The other one was manufactured. Lena sat with this for a long time. She sat with it the way her mother used to sit with the Bible verses in the cabinet. Not reading anymore, just letting the words be there. Then she wrote a 7-page memo and emailed it to senior partner Raymond Draper at 11:43 on a Wednesday night. He did not respond. She waited 4 days. She sent a follow-up, brief and professional. "I wanted to make sure the memo came through clearly. Happy to discuss at your convenience." She used the word happy and immediately wished she hadn't. It sounded like she was apologizing for taking up space. He responded on the 5th day. 3 sentences. "Thank you for the note. The decision on the Alcott matter has already been made at the partner level. We appreciate your thoroughness." She read it twice. She printed it and put it in her desk drawer. She did not know yet why she was saving it. She would know later. The motion to withdraw was filed on a Friday. Lena found out from Cheryl, who told her with the particular careful gentleness of someone delivering news they know is going to land badly. Meredith Alcott had been notified. The court date to formalize the withdrawal was scheduled for the following Thursday. Lena went home. She called her mother, who did not pick up, and then sat on her couch in her work clothes for an hour and looked at the wall. Her grandmother, who had died when Lena was 11, used to say something that Lena had never completely understood until she was an adult. "Baby, the door being locked doesn't mean the door is the last thing you try." She had said it about a landlord, originally, a man who had locked her grandmother's family out of their apartment in a dispute over a broken radiator that he refused to fix. Her grandmother had not stood there and rattled the handle. She had gone to the city housing board, and then the local paper, and then the congressman's office, and the landlord had fixed the radiator within the week. Lena thought about the door for a long time. Then she looked up the direct contact information for Meredith Alcott. The meeting took place in Meredith Alcott's kitchen, which was the kind of kitchen that had seen 7 decades of actual use. Worn wooden handles on the drawers, a dish towel folded over the oven handle, a small television on the counter tuned to a local news channel with the volume down low. Meredith was 71 and moved slowly and made coffee without asking if Lena wanted any, which Lena understood to be a form of welcome. She was not what Lena had expected. She had expected someone fragile, hollowed out by 11 years of litigation. What she found instead was a woman who had simply gotten very, very tired of being told what was true about her own life. "They think I forgot," Meredith said. She was not angry when she said it. She was something past anger, in the territory where things go after anger wears out. "I was in Phoenix to see my sister. She had surgery that week. I went out there because nobody else was going to." She set down her coffee cup. "I remember it exactly. I remember the color of the hospital walls. I remember that my sister's nurses were named Patricia and June, and that June had a sticker on her badge that said she was a cancer survivor. I remember all of it, and they looked me in the eye and told me I must be confused." Lena asked her about the wire transfer. Who initiated it? What bank branch? Whether she had kept anything from that trip, a receipt, an itinerary, anything. Meredith got up without a word and came back from the other room with a shoebox. Inside, the shoebox was a boarding pass, the original paper kind, from an airline that no longer existed, and a receipt from a restaurant near the hospital, dated and time-stamped, with Meredith's credit card number on the bottom slip, and a handwritten note from her sister, who had also since died, that started with the words, "You came. I knew you would." Lena held the boarding pass for a long moment. The paper was thin and the ink had faded, but the date was still readable. The flight had landed in Phoenix at 9:14 in the morning on that Tuesday. The document in Columbus bore a timestamp of 10:47 a.m. The distance between the Phoenix airport and the Columbus bank office was 1,642 miles. She placed everything back in the shoebox carefully, as if it mattered how she handled it, as if the paper could tell that she understood what it meant. "Can I photograph these?" she asked. "You can take them," Meredith said. "I've been waiting 11 years for someone to actually want them." She filed the emergency motion herself. She had thought about this part for 3 days before she did it. Thought about it the way you think about stepping off a curb into traffic, knowing you've checked both ways but not quite trusting your own eyes. She was a junior associate with document review access. She was not lead counsel. She was not technically counsel of record on anything. What she was doing existed in the gray space between professional initiative and professional misconduct, and she was aware of this, and she did it anyway. The motion was 12 pages. It cited the travel records, the wire transfer log, the branch manager's initials, the boarding pass, and the restaurant receipt. It cited 3 circuit court precedents on signature and 1 Supreme Court case from 1994 that almost nobody referenced anymore, because it had been decided on narrow grounds and the legal community had largely moved on. Lena had not moved on. She had found it at 2 a.m. on a Thursday and sat up for another hour, making sure she had read it correctly. She had. She filed the motion at 8:17 on a Monday morning, 40 minutes before the firm's founding partner, Hartley Calhoun, who had been with the firm for 49 years and had a portrait of himself in the lobby, arrived at his desk. By 9:30, she had been called into Draper's office. The office had a view of the city that people at the firm mentioned when they were talking about other things. The way people mention expensive watches. Not because it matters, but because it is supposed to communicate something. Draper was standing when she came in, which she had not expected. He was a tall man who had learned, over 41 years, to use his height the way other people use punctuation. There was another partner in the room, Judith Fitch, the firm's third named partner, who handled litigation and had a reputation for being the person Draper called when he wanted a decision to sound measured instead of emotional. She was sitting with her hands folded on the arm of the chair, and she looked at Lena the way a person looks at a weather forecast they find inconvenient. "You want to explain what you filed this morning," Draper said. It was not a question, Lena explained. She did it the way she had practiced. Not at home in front of a mirror, but in her head, on the train at her kitchen table. The words laid down like stones in a path, so she wouldn't have to find them under pressure. She described the date discrepancy. She described the shoebox. She described the branch manager's initials, and the boarding pass, and the 1,642 miles, and the 2018 circuit precedent, and the 1994 Supreme Court case. When she finished, the room was quiet for 4 seconds. She counted them. "We made a determination at the partner level," Draper said. "I understand that," Lena said, "but the determination was made before the travel records were cross-referenced. Test with the document. That analysis hadn't been done. We have forensic experts who reviewed the signature. They reviewed the document in isolation. They didn't have the Phoenix wire transfer records to compare against." Fitch said, quietly, "Where did you get those records?" They were subpoenaed in 2018 and filed in the case archive. They've been there for 6 years. Another silence. Shorter this time. Draper said, "You filed that motion without authorization." "Yes," Lena said. "That's a serious breach of. I know what it is." She said it evenly, without apology and without aggression, the way her mother had taught her to say hard things, not like you're asking permission, and not like you're picking a fight, but like the thing is simply true, and you are simply saying it. "I also know that Meredith Alcott has been waiting 11 years, and your firm was 4 days from abandoning her with a forged document still on the record. I thought someone should try the door." She did not explain what she meant by that last sentence. She wasn't sure she could have. Fitch looked at her for a long moment. Then she looked at Draper. Draper looked at the view. The hearing was moved. Not canceled. Moved. The motion to withdraw was tabled pending review of the new evidence. Lena was assigned, formally and in writing, as co-counsel on the Alcott matter, which was not exactly a promotion and not exactly a reprimand, and which the firm announced internally in a single line of an email that went out on a Wednesday afternoon. 2 of the senior associates congratulated her in the hallway. 3 more did not make eye contact for a week. Cheryl, from the printer room, stopped her in the elevator and said very quietly, "I heard what you did." "Good." Then the elevator opened and she was gone. The case took another 7 months. There is a version of this story where the rest of it is dramatic, where there is a climactic hearing with a gallery full of onlookers, and a judge who delivers a speech about justice, and Draper shakes Lena's hand and Meredith cries in a way that photographs well. That version is cleaner and more satisfying, and it is not what happened. What happened was 7 months of depositions and record requests, and a forensic handwriting expert who had to be retained and briefed and deposed herself. What happened was a Saturday in August when Lena sat in the conference room until midnight, going through 38 years of account statements, looking for the secondary pattern that she had noticed in the archived records and needed to prove beyond the range of reasonable dispute. What happened was a phone call from her mother on a Sunday night, during which Lena sat on her kitchen floor because the chair felt like too much effort, and her mother listened for a long time without saying anything, and then said, "You still in it?" And Lena said yes. And her mother said, "Then keep going. That's the only strategy that ever worked for anybody." The ruling came on a Thursday morning. Lena was in the office when it came through. She was at her desk, drinking coffee that had gone cold half an hour ago, and reading the 14th version of a brief that was due the following week, and she almost missed the notification in her email. The trust transfer document was ruled fraudulent. The bank account was ordered restored to Meredith Alcott's direct control. The son, whose name Lena had read so many times in case documents that it had become, in her mind, less a name than a recurring clerical error, had agreed to a settlement 2 weeks earlier, once the evidence had been formally entered and the handwriting expert's report had been filed. The judge's written ruling was 9 pages. On page 4, in a section that Lena would later read 4 times standing at the copy machine, the judge wrote, "The evidence establishing Mrs. Alcott's physical impossibility of signing the contested document on the date in question was available in the case record for 6 years. Its significance became apparent only after a comprehensive cross-referential analysis was undertaken." Comprehensive cross-referential analysis. That was what they were calling it. Lena finished her cold coffee and went back to the brief. Draper came to her desk that afternoon. He was not a man who came to other people's desks. He was a man who sent calendar invitations through his assistant for meetings held in rooms with views. The fact of him standing in the associates section of the open office, next to Lena's desk, with its single-framed photograph, and its slightly tilted monitor and its stack of flagged case files, was so outside the ordinary pattern of things that 2 of the associates at nearby desks stopped what they were doing and looked. He said, "Good work on Alcott." She said, "Thank you," he said. "I should have read the memo," she said. "Yes." There was a moment where he seemed to be deciding whether to say something else. He was 63 years old and had spent 41 years learning to be precise with language, and she could see, watching his face, that he was choosing between several different sentences, and none of them quite fit. He settled on. The forensic work was thorough. She said, the records were always there. He nodded once, in the way men nod when they want credit for the nodding, and went back to his office. She did not watch him go. She called her mother that evening. She sat on her couch, this time, not the floor, and she told her the whole thing, the ruling, Draper at the desk, the judge's 4 sentences on page 4. All of it. Her mother listened. When Lena finished, her mother was quiet for a moment. Then she said, that woman in Phoenix. The one who wired the money. 11 years she's been waiting for someone to believe her. 71 years old, Lena said. A pause. You know what I always say. You always say a lot of things. I say. The door being locked doesn't mean the door is the last thing you try. Lena looked at the ceiling. She thought about the shoebox. The boarding pass with the faded ink. The note from Meredith's sister. You came. I knew you would. Written in handwriting that had clearly been hurried. The letters slightly uneven. The way people write when they're tired and relieved at the same time. She kept everything, Lena said. 11 years and she kept every piece of paper. Because she knew it was true, her mother said. When something is true, you keep the evidence. They talked for another hour about other things, about the heat in Cleveland and a cousin's new job, and a recipe her mother had been experimenting with. Ordinary things, strung together like lights. When they hung up, the apartment was quiet. The city outside Lena's window made the sound cities make at night, traffic and distance, and the low hum of everything running. She thought about Meredith getting the call, a woman of 71, who had kept a shoebox for 11 years, who had remembered the color of her sister's hospital walls, who had been told she was confused about her own life and had simply refused to believe it. She had not raised her voice. She had not done anything dramatic. She had just held on until someone with the right door key showed up. And when that person arrived, younger than she'd expected, with a file folder and a visitor badge, and a way of going quiet when she was the most upset, Meredith had opened her shoebox and said, I've been waiting 11 years for someone to actually want them. The records had always been there. Someone just had to read them.